signs of life. Please don't tell me that the human race did not survive. There are no people in the future. There are no people. There are no people in the future. No people at all. There are no people in the future. Where did all my people go? There are no people in the future. Let me try my people call. Guess I'll fly away now.
Hey, everybody. Welcome. It is Monday, February 26, 2024. Welcome to Raging Chicken's Out to Coop Live. This is Kevin Mahoney, editor and founder of Raging Chicken. On Out to Coop Live, we talk to progressives, activists, and troublemakers of all sorts, right from our own backyards and across the country. You can join us at the end of the week for our Friday Politics Roundup, where we break down the good, the bad, and the ugly in state and national politics. And you can get all our shows by subscribing to our podcast on Podbean, iTunes, Spotify, or wherever you get your podcasts. And you can support this show by becoming a patron for as little as $5 a month. Head on over to patreon.com/rcpress for all the details. You can also help out the show by heading over to our YouTube channel if you're not there already. Smash that subscribe button, like the stream for this show, and hit that notification bell so you know every time that we go live. And if you're one of our awesome podcast listeners, make sure to leave us a 5-star review on whatever platform you listen on. Leave a comment too so folks know why you like the show. Little things like this help other people find the show. That's how we do this, folks. For more PA Progressive Talk, tune in to the Rick Smith Show's live stream at 9 p.m. Eastern, YouTube, Twitter, Facebook, wherever you get your streams, and subscribe to his podcast wherever you get your podcasts. Check out thericksmithshow.com for the latest across all his platforms. And you got to check out the Sisters of the Night Caucus podcast. The amazing PA women stirring the political cauldron behind this podcast rock the house, and they know where the bodies are buried. Make sure to follow them on Twitter at the Night Caucus. That's at the Night Caucus on Twitter, and subscribe to their podcast on Anchor, Spotify, iTunes, or wherever you get your podcast. And of course, you got to listen to The Signal. That's the flagship podcast from the Bucks County Beacon. The Signal is hosted by the Beacon's editor-in-chief, Cyril Michaleko, and produced by yours truly. Twice a month, The Signal will shine a light on right-wing extremist currents streaming through Bucks County and beyond. Cyril invites guests who can provide insight, analysis, and organizing solutions so we can steer the community toward calmer, saner, progressive roots. Check them out at buckscountybeacon.podbean.com or wherever you get your podcast. Also, The Civic Circle is a podcast by the Bucks County Beacon, tackling politics and policy from a Gen Z lens. Sarah Zhang, Mallory Marson, and Alexandra Coffey are students from Bucks County, Pennsylvania. And once a month, they chat about activism, advocacy, and all the political happenings affecting their generation today. Check them out at civiccircle.podbean.com. That's civiccircle.podbean.com. And attention all you gamers out there, the Game Inn, that's with 2 N's, the Game Inn is a Quakertown-based black family-owned gaming store. They're friends of the show, and they've got everything for retro N64s, the latest consoles, video games for all platforms, collectibles, action figures, Funko Pops, walls of Funko Pops, and kids get discounts when they get A's in their report cards. You can't beat it. Check them out on their Facebook page and follow them on Twitter at the Game Inn, that's with 2 N's, at the Game Inn. Yes, got a question about a game, looking for something hard to get, shoot them a message or drop them an email at thegameinpa@gmail.com. And if you find yourself in the Kutztown area, you got to check out the Heart and Hearth Deli and Smokehouse. Located at 466 West Main Street, kitty corner from the Kutztown University campus. The Heart and Hearth is an American bistro featuring barbecue and French-inspired fare, all with locally sourced and organic ingredients. Check them out, www.heartandhearthcuisine.com, or on Instagram at Heart and Hearth Deli. Shout out goes to Jonathan Mann, who wrote our intro song, There Are No People in the Future. Check out all his great stuff and follow him on his YouTube page or on Twitter at SongOfDayMan. That's at SongOfDayMan on Twitter. Well, we got a great stuff coming for you tonight, everybody. I've been plugging this for a bit. I've been waiting for this night for a while. I'm very excited about it. And tonight's show, I welcome Steve Oross and Lorrie McKinley to the show. Steve Oross, as many people listeners to the show will know, is Associate Professor of Psychology at Kutztown University. And you remember, in the fall of 2021, Steve Oross was denied ADA accommodations by Kutztown University's administration. Oross had a heart transplant in February 2021. Following months of physical therapy and treatment, his doctors cleared him to return to work in fall 2021, with one condition, provided that he taught his classes online, given that COVID was still rampant and would pose a significant risk to his life. Rather than providing Oross with accommodations, the administration said the only way they would allow him to return to work would be if he taught in person. Rather than risk his life or being forced to go on unpaid leave or losing his job, Oross decided to fight. And that's what we love around these parts. Thanks to his determination and the amazing advocacy of his attorney, Lorrie McKinley, Oross won his case. Steve's experience has led him to wider spheres of advocacy as well. He's a team member with the World Health Network focusing on legal action for policy change. He has also become involved in the Organ Donor Awareness Corporation, which is a student-led organ donation advocacy group with chapters in New York City, Nashville, Tennessee, and involving students from around the country. And he's going to be participating in a series of webinars with this group focused on promoting organ donation among young adults. And Lorrie McKinley is one of the few lawyers in the Philadelphia area with undisputed expertise in both employment law and special education advocacy and litigation. She is a passionate, bold, and creative advocate with a long track record of protecting the civil rights of employees and students under the nation's civil rights law at every level of the state and federal courts. Lorrie is widely recognized for her contributions to the employment provisions of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, as well as her advocacy on behalf of children with special needs. Prior to entering private practice in 1997, she served as a project head for the Employment Law Project at Community Legal Services Incorporated in Philadelphia. In 1997, she argued before the U.S. Supreme Court in a case involving constitutional due process issues for people receiving medical benefits pursuant to Pennsylvania Workers' Compensation Act. And her work on that case is highlighted in an exhibition in the Supreme Court section of the United States Constitution Center in Philadelphia. For over a decade, she has been selected by her peers as one of the best lawyers in America. And since 2008, she has also been listed as a super lawyer by Thomson Reuters based on peer recognition and professional achievement. Welcome to the show, Steve and Lorrie.
Thank you, Kev.
You betcha.
Thank you.
Oh, you betcha. So, yes, I know it's a long intro, everybody, a long bio stuff, but I want to make sure we got a little nice and situated for tonight's discussion because this is a perfect example of what it looks like to fight and win in the face of an organization that is kind of openly attempting to discriminate against people. And people who are in situations that are, potentially dire, where they're risking their kind of life and limb, literally. So I appreciate you both being here tonight, and I know that I've been getting email ahead of tonight's show, thanking me already. It's like great to have you back on. Wondering where the case was now, and wanted to hear you back on the show. So thanks again for being here.
Oh man, that's nice to hear. Glad to be here.
Yeah, this case has not gone away in people's minds, that's for sure. So what I thought, again, this might be, I put links in the show notes, kind of in our show here. It'll be both in our podcast and our YouTube page, where if you want to go back and check out the last time Steve was on the show was like right in the face of him being denied ADA accommodations back in 2021. And that is linked directly in the show notes. You want to go back and hear that whole conversation because it is a infuriating litany of events that took place to work every way possible to try to prevent Steve from coming back to work. It was the most incredible thing I've ever seen, but not unfamiliar in my experience of working at Kutztown for sure. But for those folks who might be new to this or are coming to look at the most recent legal case and stuff, what I thought might be kind of useful is just to give us a kind of a brief lead up of kind of like what happened here. What happened in 2021 that got us to the point where, okay, it's like, it's either I fight this in court or I risk my job or my life. Right? Steve and, Lorrie too, if you feel like they're kind of stepping in at any point in here. But Steve, maybe you could kind of take us through some of those events about what led us to this court case.
For sure. And let me back up just a hair further back.
Please.
So I had been living for a number of years with a severely compromised heart that was damaged back in 2014. And while I had to take some time off from work, I was back at work. And in 2020, I really started struggling and ultimately ended up that I needed a heart transplant. So I took a medical leave in the spring of 2021. I got the heart transplant. Fortunately, went pretty well for me. I was released and entered into a rehab program. Also, fortunately, by the end of the summer, the doctors were saying I could come back to work sooner than we had thought, but they were saying, yep, you can come back. But there were conditions put on them because of COVID being present and because, and this is an important point too, the lack of precautions and mitigation efforts on the part of Kutztown. So I honestly thought this was a simple deal. I contacted HR informally just to start the process. What do I have to give you? What do I have to provide so that I can continue teaching remotely? And I got a note back saying, nope, not going to happen. You're not going to be allowed. And I thought, are you freaking kidding me?
Well, this must be some kind of mistake, right?
Yeah. And I thought maybe what they meant is I needed to formally request, so ended up, I wrote a formal request for accommodations from the ADA, got the exact same wording, exact same rejection. And it just didn't seem right to me. It didn't seem to fit my understanding of the ADA, didn't fit our own university policy. And so I started internally speaking up. There were a couple rallies, people came to my support, but I approached a disability rights advocacy group, Disability Rights Pennsylvania, who contacted Kutztown on my behalf, sent a letter to them in early October of 2021. And they outlined how Kutztown was violating the law, offered a simple solution to get me back to work and simply get my back pay that they had denied illegally. And Kutztown escalated. They threatened to fire me. They threatened to cut off my health benefits and terminate my job. And DRP, again, Disability Rights Pennsylvania, said at that time I should contact an employment lawyer. And that started the search. They gave me some recommendations, but I started reviewing people and fortunately contacted Lorrie, who was willing to take on the case. And we filed the formal complaint in mid-November of
2021, right?
So, of 2021, yeah, mid-November. And followed that a week later with a request for a restraining order to keep Kutztown from firing me, because they had stated that if I was not back in person by December 29th of 2021, I would lose the job, lose the health benefits. And we'll come to this, I'm sure, but they stated a policy that they claimed justified their decision. And that's when we started the legal battle.
So let me just paint this picture too, just to remind everybody too. In the fall of 2021, a couple things happened. Steve has already kind of alluded to it, but Kutztown University was one of the first universities in the state system, right? Once that there was some loosening of masking requirements to basically drop all masking requirements. Masking was then kind of suggested. And then there was also a big uptick of COVID cases again in fall of 2021, as was expected, right? All the warnings were there. People were coming out here, but the president of the university, Kenneth Hawkinson, was insistent that everyone went back in person with minimal protections. And that the reason why that posed such a threat to Steve, of course, is because he had come to us off a heart transplant, right? And his life was at risk. If he had COVID, right, he could die. I mean, it was a pretty straight line from there, right?
Yeah, and at that time, with that strain of the variant that was available, the estimates were that if I caught COVID, there was a 30% chance of dying. I mean, if you think of it, it's a 1 in 3 times you go out your door, you're going to die. And so the doctors were adamant. There was no chance for me to come back in person.
100%. So, Lorrie, let me shift a little bit with you. So, so Steve gets in touch with you on these kind of recommendations. So from your perspective, like, how did you decide to take the case? Why were you invested in taking this case? And maybe a little bit about kind of like what you kind of brought to the table as an advocate around these issues.
Well, I had decided to take Steve's case before I returned his phone call. Actually, the funny story is that my office manager at the time talked to him on the phone, and I was busy doing something, and she came running back. She said, you need to call this man. You're going to want to take his case. And I was like, yeah. She came back a half an hour later. Have you called him yet? And came back again. Have you called him? I said, all right. So I looked at it, I said, oh, I pick up the phone, and I've joked with Steve a few times that, I would have paid him to let me do his case because this was right up my alley. I've been doing employment-based or disability-based employment claims since even before I was out of law school, at community legal services, which is where I got started. And it's been a big focus of my career. So this was really an important issue for me, partly because at that time, of course, we had people like Steve who were in a really vulnerable situation with regard to their ability to return to work and the danger of doing that in a congregate setting for people with these kinds of severe risks. But the other thing is the whole idea of remote accommodations as something that can provide access to the workplace for people with disabilities more generally. What I'm trying to say is not just about COVID. And that has been a really long fight. And prior to COVID, even though the courts have said time and time again that as technology gets better, there are going to be more opportunities for people to receive these kinds of accommodations and to be able to participate in the workforce, which is really the whole point of the civil rights laws.
Right.
So once COVID got started, it was very obvious, especially in the university type setting, that, the technology was not only developing, it was there, and there are so many different ways of conducting really high quality, education remotely. And so it just seemed like a no brainer for me that I was this was my case. And, I've never really looked back. And I think that, Steve and I have worked really closely together, and it's just been a long saga, but we're not done yet, but we're well on our way, hopefully.
So when you read this, so did this stand out to you as like, oh, this is clear? I mean, there's not even a question here about discrimination in that. And how did that maybe compare to other kind of cases you work? Did this one stand out as like, this is a, this is a shoe-in because of how how in your face it is? Or was this kind of had some complications of approaching the case?
I actually did not see it as very complicated. I thought it was a no-brainer. Mm-hmm. I mean, I actually thought that this was going to be one of those situations where you basically write a letter or you file your lawsuit because the letter ought to be written. And we didn't have a lot of time because of the situation Steve was in. But I thought I'd file the case and somebody would call me up and say, oh, what can we do to make this go away? So I am more shocked than anyone that here we are, 2.5 years later, about 2.5 years later. And, we're still working on this. So the aggressiveness of the pushback from the university was very surprising to me. And I really couldn't understand it because I just thought from a public relations standpoint, put aside the law, this sounded like a nightmare to me. But that didn't seem to make any difference. I think, it just seemed that there was sort of a line in the sand, and that's what we were dealing with. And so it's just been very difficult to move that.
And was it your sense? I mean, this is just something that I'm very curious about from your perspective on this too, as well. Is like, for me, it would seem like once the university decides to fight this, that the stakes of the case go up, because like in a sense that if the case gets lost, what it would mean for those folks with disabilities, right, and what it would mean for the ADA would be problematic. Would you say that?
Absolutely right. And as I said, it's not just about COVID. So I think that would have been a really bad result. But it just seemed to me that given where we're at and given the kind of employment setting we're talking about, that this just isn't rocket science. There's no dispute about the disability, no dispute that Steve had medical documentation that he needed this kind of accommodation. And, Steve, like lots of other people, Kutztown had been teaching online for years. Okay, so nobody was teaching 100% online. That doesn't matter for purposes of an accommodation discussion. The question is essential functions of the job. What is the job designed to accomplish? And, teaching is what a professor does. I mean, there are other things too, but there's nothing, magical about that has to be done in the classroom. You can put Ichabod Crane in a classroom.
Right.
He might not be able to deliver the instruction that we're anticipating. So, or that students, have paid for and are entitled to. So the issue is, can Steve or someone else in his position with this type of access accommodations, that's really what it is. It's not about giving him something to help him do the job. It's just giving him access to the classroom. Because his request was to teach synchronously. So basically, under his, what he was asking for was that he would be the only person not in the room. The students would be in the room. Mm-hmm. The only person accessing the classroom remotely would be him. Everything else is going to be the same. The instruction would be the same, the materials would be the same, the outcomes would be the same. It was a very simple fix. And in fact, the judge has said a number of times, well, I've been to other places and I see people, doing this all the time. Like, what's different about your students? So, I think there's been a lot of head scratching about this, like how it's possible that we're still here 2.5 years later.
It's amazing. And I just got a message in from our, in our chat, it says from Social Studies Rock, says, I'm facing this right now in the PASHI system with an ADA for heart failure being denied. So, it seems that the university has also decided that, or not the university, but the system had just seems to learn the lesson. As a matter of fact, this just came up. We saw a new job description from the PASHI that was through Kutztown University, that basically hiring a special investigator for any case that might cause litigation for the university or political consequences. We're like, are you serious? Is this a response to what's going on right now here with Steve or not? So it's pretty crazy. And Dan says, once the main topic is completed, is if you could, I wonder what experience Ms. McKinley might have with retirement being rescinded out of spite. Well, we can get to that down the road, Dan. Thank you. It looks like Steve, are you still there? It looks like somehow Steve lost his connection. Hopefully Steve will be able to kind of drop back in. And then we'll kind of move that. So, well, let's move ahead, Lori, then to once this finally goes to court. It just finally goes to court this past year, correct?
No, we started out very aggressively, and the reason was, well, it was a case that demanded instant action because Steve was about to lose his medical benefits on December 29th.
True.
So
right.
I first met him in sort of late October, I think it was. It was right. I think it was the day before the rally, which was in October. Mm-hmm. So, putting together a lawsuit is actually not something you can just do in 5 minutes. It takes time to pull it together.
Right.
But under the circumstances, I decided to take what is a very unusual step in an employment case, which is to file for a temporary restraining order. And the reason that it's unusual is because most of the time what courts will say is, well, if the case is something that we can fix later, like after you win by writing a check, well, there's no irreparable harm. So maybe, you can show me right now that you're probably going to win, but without the irreparable harm, I can't give you relief today.
Right.
So we filed for the TRO and we got it. And it was really amazing because I heard from a lot of people, like friends of mine who were lawyers, and they said, I can't even believe that you filed for a TRO, much less that you got one. In an employment case, it's really very unusual. So again, I thought, okay, we're doing great. This is going to be over soon. But that's not what happened. But the upshot from the TRO is that Steve was, or the university was ordered to let him come back to work, starting with the winter term. So he's back for the spring. So we were able to get him back, even though the case continued. So it's a temporary, well, it turned out, we ended up, yeah. So anyway, so pending litigation. So it's not an order that says you win. What it says is you're probably going to win. You have a substantial likelihood of prevailing on the merits, and it would be irreparable harm for him not to be working while this process goes on. So that's what happened.
So there's this step one. And so this case then continues and goes on, and then we finally get a ruling on this last summer, correct? I mean,
July 25th.
July 25th, 2023.
Yeah.
And let me just kind of like, just give people a flavor of some of the opening sentence of the conclusion of this case. This is directly from, it says, conclusion, in sum, instead of showing compassion to a valued tenured professor who, despite having recently underwent a heart transplant and was trying with, quote, all his might to return to campus, unquote, for the fall 2021 semester, the university showed callous indifference by refusing to consider Professor Oross's individual circumstances as the law required in favor of summarily denying his request for remote accommodation based on recently devised, inflexible, and unsubstantiated policy that any request to change the course of modality from in-person to remote would be considered a substantial alteration to the course offerings that would represent an undue hardship to the university and its students. I mean, I don't know about what you all, I mean, we can get into more some of the specifics in the case, but reading that at the end, and that's one of the quotes that was making it into the papers, that made it in the Philadelphia Inquirer, that made it inside Higher Ed, that made it a whole bunch of other places that were reporting on this. That seemed to me like the judge basically saying, this is unconscionable what you did. I mean, I don't know if that was your sense of it, but reading this, that's what it seems like to me.
Yeah, he was more eloquent than I was, and I can wax poetic in these kinds of situations, as Steve can attest. Because it's but yeah, he was obviously that is unusually strong language from a federal judge, I think.
Yeah, there were. I mean, that was when I first read it, I thought, we're finally over. The university has to recognize that the court is really ticked off about this. There was another statement that always stuck with me from that same ruling, when the judge stated that the university did not make any effort, let alone a good faith effort, to accommodate me. There's this another one is they're saying you didn't do anything to follow the law, and I thought for sure that would get through the heads of the administrators and the case, result in it ending.
Right, and that was by design, right? I mean, because this wasn't done under Kutztown's published accommodation policy. This was a secret blanket policy that was devised, as the court said, a mantra that was devised to apply to anybody. Didn't matter whether it was Steve or anyone else, and it was just a blanket, no, you can't have that accommodation, period.
Well, and it seems like this is one of these cases, too, where, for any individual being faced with the university, well, this is the policy, right? And you have that sense that, like, this is not right, but you don't know. But in the case of law, like when you're in a court of law, they have to basically prove this stuff. So what you're just saying there about this policy that they just slapdash put together, this was something that came out in the findings in the court, correct?
Well, it did. But, when you talk about proof, I mean, that's another interesting thing about the way we litigate this case. Usually the plaintiff does have the burden of proof. We're the ones that have the obligation to prove discrimination. And so, again, it's unusual for a plaintiff to go into court after discovery and say, hi, judge, here's our case. We're entitled to judgment now. No trial. These are the facts. They're undisputed. The facts are almost all undisputed. And so, we want you to issue an order right now and give us relief. So that's what we did. That's a very unusual thing for plaintiffs' lawyers to do. I've been doing them for a long time in ADA cases because I think a lot of times the facts really can be decided that way. But especially so in a case like this, which is about the policy, the application of a blanket policy. We just say no. That's what, you can't do that. People can't hang up signs on the, university door that says people with disabilities can't work here.
Yeah, it's like seeing like the big like wheelchair sign with a cross through it, right? As if that's their policy.
Exactly. And it's no different. It's just a virtual ramp essentially, as opposed to a physical one. But the access issue is exactly the same. And you can't have a blanket policy. I mean, that is just bedrock law. under the ADA, Section 504, even before that, that it always has to be individualized. So when you read what the judge said on the last page, he talks about that. There was absolutely no individualized assessment of whether this would have been an undue hardship to the university, because the way their blanket policy worked, their mantra, as he put it, it was no questions asked, no. Mm-hmm. So, again, I felt really confident about doing it. And, you have to do this whole big thing of undisputed facts. And really, most of the facts that we needed to prevail on most of the claims that we brought were not disputed. There was just no question. That's what happened. Their argument was, it changes the nature of our business because we're an in-person institution. No, it doesn't.
Is that literally all they had? Is just like, well, we say that it changes our business.
Pretty much.
Yes.
Yeah.
Wow.
Yeah.
But it doesn't. And the point is, an accommodation is, for one person. We're looking at one person at a time. We're not talking about, everybody in the university that might want to make a lifestyle choice. Like, oh, well, it was pretty fun for us, teaching remotely. I think I'll ask to be able to do that. I mean, that is not what we're talking about. We're talking about accommodations for people with disabilities under federal civil rights laws that say people have to do things differently in order to give access to a person with disability, which is what our case is about, or some other kind of accommodation and other kinds of cases. But, this is the way we've always done it, or this is the way we want everybody to do it now. We want everybody back to campus. My favorite line from Hawkins's deposition is no matter what. So it was there was no individualized assessment. The whole point was that there would be none, and that is not what their actual policy says. But this is how they implemented their blanket policy, and that is what got them in so much trouble, so much so that we were able to get these rulings at a very unusual time.
Yeah.
So I really can't believe that we're still here, honestly.
It's amazing. So, Steve, what, from your perspective, heading into this case and kind of seeing the deposition, seeing what the university was offering, and then from your experience, what was that experience like for you going through this?
Well, there are probably certain things I can't say about my emotional reaction to
Fair enough. Smart man.
People can probably infer, and if you want to browse through records, I'm sure you can find places where I said exactly what I think. But honestly, the first sets of emotions.
Oh, we just lost Steve. First set of the moment. Hopefully he'll be able to come back in. He's been having, everybody, sorry about that. He's been having a couple issues with the connection on Steve's end. So he's been able to kind of jump back in each time. So we'll come right back to that kind of in a second. So Lorrie, let me turn back to you then. So if all they had, here's what strikes me is that if all they had going forward is like, well, we decided that our model was X, and it's not based on kind of objective reality. As you said, there's already an infrastructure that was built in response to COVID, but had been it's even in the case that it's in the mission statement of the university that distance education is an important part of the university's mission. So in their own materials, it was there. So the infrastructure is built, right? We've already had experience that has been, by the time we get to 2021, faculty had a significant experience, right? And really had upped their game in response to what was going on with COVID. Students had gotten used to this. So, I mean, I can't even imagine being in a courtroom with people that have no evidence, they have no argument, they're not refuting any of the case, but all they have is, well, this is what we want to do.
Yeah, I mean, because the standard the judge is supposed to apply. The issue, it's not as simple as just saying, I want an accommodation. I mean, you have to show that you have to document it. You have to show this on an undue hardship to the university. So, but undue hardship is their burden. They have to prove that. And that means significant difficulty or expense. And it's admitted that there wasn't a significant I mean, they never challenged that. Their argument was, it's a fundamental alteration, which is a different standard that applies for public accommodations. So for instance, it would apply to students, but not employees. But even if it did, the judge said there's no fundamental alteration to your entire business model because you have to give 4 remote classes to Dr. Oross. I mean, that's just not a thing.
Right. Right. It's crazy. Steve, sorry we lost you there for a minute, Steve, but you were right at the point you were saying, like, your initial set of feelings on this case.
Say what you were thinking, and you went and said it outside.
Yeah, sorry, I froze up there. I don't know what happened.
Yeah.
So, initially, because I remember this conversation when I was applying to come back in the very beginning, and I was getting ready to write to Jennifer Weidman in HR. My daughter was in the office, and I was talking about I was going to have to request that my classes be remote. And she said, well, will that be a problem? And I said, well, no, hell no. I mean, we just did it for the pandemic. I've done it even before the pandemic. Of course, this will be fine. And she offered at that time, I'm at that time thinking, oh, this won't be an issue. She offered to stop going to her undergraduate college because she was concerned that I wouldn't be working and have pay coming in. So, I mean, that shook me a little bit, obviously. I wanted her to finish it. And then when they did, in fact, deny the accommodation with this, the rationale, it's a fundamental alteration of the format of the class, and therefore we can't do this. I was initially stunned. Then, frankly, I started getting angry. I started obviously speaking up on campus, but then what escalated sort of my anger with the university was I started hearing from others who are being denied. So there were other faculty being denied accommodations. And then I was getting messages from students saying they were denied. And I thought, what kind of university does this? We're supposed to be a higher institution of learning.
Well, and its new mission statement that it's branded all over the place says it's a caring community too as well.
Exactly. So I went through this, shock, surprise, anger, and then started becoming a little more systematic and thinking about where do we go.
It's pretty crazy. I mean, were there parts of that testimony that you heard or from the kind of university officials that really stood out to you? That either as because I would imagine a lot of this is kind of vindicating, not just in terms of like you were right about an argument, but also in terms of recognition that like, yes, this is kind of what I suspected was going on. And yes, I wasn't a crazy person, right? That this is what was happening.
There were a lot of things that stood out in some of the testimony. I'm sure I'm not allowed to say.
You can talk about what the testimony was as long as you're accurate. Yeah.
Well, I'll be careful on that. But I'll just say that there are a lot of it that surprised me. There was certainly vindication. But I have to say that even from the very beginning, even though there's always a doubt on whether you're actually going to prevail in the court of law, I was fairly confident. I remember telling people, my friends and family, that I was 95, 99% sure that I would ultimately prevail. I thought it would be a lot faster than it's turned out to be. But doubts crept in here or there when it kept going on and on. I think I just want to be careful so I don't misstate things that were in the testimony. I think the surprising part, the biggest surprises for me in the testimony were the shifting explanations for the denial and the discrepancies between what KU administrators were reporting in terms of the amount of training they've received regarding the ADA. And the discrepancies surprised me because I would have thought these administrators and certainly in HR would have extensive and ongoing ADA training. And there are a couple people who claim that, but the data was suspect there.
Right. Well, let me read just one section from, again, this is from the file from the decision. And this is from Mr. Jesus Pena. Pena, he was the guy ahead of social equity, right? So the person who is supposed to be ensuring that people, say, with disabilities from protected classes are protected in the university. So this is what he said at one point. He says, concerning the same issue, this is about the denials, Mr. Pena testified that, quote, the position we took was that converting in-person classes to online would be a fundamental alteration of our operations or the business nature or the nature of our business. We are an in-person institution. We are not an online institution. So we believe that fundamentally altering our operations or the nature of our business would constitute an undue hardship. And as such, that would not be a reasonable accommodation under ADA. Mr. Pena further testified that online classes are, quote, more an exception rather than the rule. We will offer online classes, let's say, during the winter or summer months so that students have an opportunity to get additional credits, graduate time, or graduate earlier. Also, if you're targeting a certain population, let's say your non-traditional students because they work all day or something, blah, blah, blah. He goes on, right? So it's only in this exception. What it sounds like to me, when I hear that, I hear like this is like the university as it's constructed by a PR firm about what it is, and then attempting to say that this is what we actually are, as opposed to saying, no, that's not how the university was operating. It's not how it has operated, right? And let's put that matter aside. That still doesn't kind of sidestep the law because you believe you're a particular kind of institution. I mean, am I barking up a wrong tree here?
No, and that was what I said earlier, that you can't say, well, this is just the way we do it here. We only offer online classes in this circumstance or that circumstance, or, if somebody's going to teach part-time here, on campus, we can give you a remote teaching assignment. And so for that assignment, it's not, we can do that without a problem.
Right.
It's not, an essential function for you to teach that class remotely, but we're going to say that as a matter of a policy, automatic, you can't teach these other. I mean, it's just a ridiculous argument. But the way you usually do things isn't the issue. The issue is, can you make an accommodation, do something different, modify the way you ordinarily do things to allow this person to perform the essential functions of the job, not marginal functions, essential functions. So the fact that you would rather do it some other way isn't a defense. And it was very frustrating for me to have to just, go on and on, having these arguments about things that really we shouldn't be arguing about because it's so fundamental black letter law.
Well, yeah, and let me add to that. It was astonishing to hear them say that when there were online courses continually being offered. And yes, they tried to excuse away the circumstances under which online courses were offered, but varying percentages were thrown out. I know at one time it was up to like 20% of the courses were still being offered online, but no, you can't get it if it's medically necessary. But for these other cases, yeah, sure, we can do it, and that's not changing our model. It's bizarro land, really.
Right.
It's like it made no sense to me.
Well, and what was astonishing to me is that in the lead up to this is before COVID, is that the strong push at the university was for more online classes. And so I'll tell you, I was a person who fought online classes. I did not want to teach online classes. I wanted to be an in-person instructor, right? And that's what I wanted. And we were continually pressured to teach more classes online because of those very same business interest of the university, right? And then COVID came along. Okay, well, I guess I'm gonna have to learn how to do this right and do this well. It took some time, and now, okay, I still offer one class online, right? And because it meets needs of students, right? And I've learned to do it in a way I think is fairly pedagogically sound. But so it was the university switching its mind even about what it was prioritizing, right? It was even lying to itself about some of the history of there. But it's unbelievable to me.
Right. Well, and to me, it doesn't even matter. Let's say they ordinarily never offered classes online. I think that given where we are technologically speaking, that wouldn't be the end of the case. It may not have ended as, soon as the case isn't over yet, but the legal claims have been decided. for now anyway, unless there's some appeal down the line. But I think that you would still have the issue of whether the court can compel you to provide an online accommodation for someone who is otherwise qualified to perform the essential functions of the job, which in this case would be teaching and doing service and stuff like that. So, obviously it was a lot easier. It's a way easier case for us because of the plethora of online offerings even before COVID. And all of the extra equipment and everything that they obtained like during the early part of the pandemic, and then they tried to sort of, crunch back the number of offerings to sort of, I think, improve their, like Steve said, a new shifting explanation. Oh, now we're offering fewer and fewer of these classes, and we're like hiding some of that equipment or getting rid of it or whatever. Well, okay, it doesn't really matter. You can put it in the closet, but the court can make you take it back out again. But now, because of student demand, they're having to increase the number because students actually want these courses. They might not. A lot of students, they want to have a college experience. They don't necessarily want all their classes online. Some do, because you have a lot of non-traditional students at Kutztown and lots of other places too. But, they are demanding flexibility and to be able to, and Pashi did a study in the summer of, was it 20 or 21, Steve? That basically said that's what students want. They don't necessarily need or want
it would have been
all of their classes.
As they were merging the schools out west.
Yeah. So, they had their own studies that showed what parents and students wanted and were expecting and were perfectly fine with.
It's crazy. All right. So I promised I was not going to keep you guys all night here. And I believe me, I would love to dig into every aspect of this thing.
Don't worry.
No, okay, good. I'm going to tell you, just let me know, like raise your hands, but I know everybody else can't see you. You can tell me like, okay, Mahoney, cut it. Right? So I
got all my.
Great. All right. So then 2021, I don't want to move off. I'm sorry, not 2021, 2023. And that case that was decided there, I don't want to move away from that too quickly. If there's other things you think we should talk about, but, you won that case. I mean, like we read that kind of conclusion there from the judge. This was like, kind of open and shut case. You hit it out of the park, and the university had nothing to stand on, did not contest any of the facts of the case, and just said that we just don't want to accommodate people with disabilities. We just don't want to make accommodations because, and that was it. That was the argument. Because
that was the argument. Exactly the argument.
It was like a third grader's argument about how you kind of deal with people with disabilities or people that are being kind of systemically now discriminated against at the university. And like Steve said, right, there were many other faculty members that were also got the same stuff. Unfortunately, I wish we had all these cases go forward, to be honest with you. And now we've got, someone in our chat saying another Pashi institution for a similar situation is being told exactly the same things that Steve was told as a way of denying a changing a modality. I mean, it's like, it's unbelievable to see this kind of intransigence.
Yeah,
I will state that I've heard from a lot of other faculty from multiple Pashi schools who are hearing the same thing. Not everybody has yet gone forward, or may not yet, may not ever go forward with the lawsuit. But this kind of reasoning that the court shut down is still being used in schools.
Yeah, and not just in Pashi schools. It's being sort of adopted and morphed to be used in other kinds of institutions also, which I think is really astonishing, because I don't think there's anything particularly surprising or out of this world with regard to what the judge found in this case. I mean, because again, most of our facts were undisputed.
Right.
So when you lead, it's sort of like breadcrumbs. Like you follow his breadcrumbs. The guy's got a disability, medical documentation, needs the accommodation, and let's look at this job. Yeah, he can do this, remotely, perfectly fine. But people have been doing it for years. Sometimes, I know I've said this to Steve, and he said it to me. It's like, why are we here?
Yeah.
Why are we still here?
I will add to that. If I may add to that, though, one of the things the university then did along the way was to try to have me classified as unqualified. And that would have made it impossible for me to sue. And the way they tried to do that was to implement what they had called the full-time, full-duty rule. I had to come back to work full-time, full duty. That's not written anywhere. There is no written policy anywhere about this. And when I pressed them over and over, they finally came back and argued that in-person teaching was an essential function of teaching, of the job. And since I couldn't be in person, I wasn't qualified for the job.
Wow.
But that was another point that the judge caught on. So there was that initial policy issue of, well, where everybody has to come back. But then they made up a policy. It didn't exist anymore.
They did make it up. And even Dr. Hawkinson, when I asked him about it during his deposition, well, did you know about this policy? Do you have an idea where it came from? President of the university doesn't know, and neither does the HR director. And then they say, oh, it came from Pashi, so it's not our fault. Well, okay, I don't really care, because you're the university, you're the defendant in the case, you're responsible for providing accommodations to Dr. Oross. And I don't know, it's been 25 years since it's been flatly illegal to have a full-time, full-duty policy without any exceptions. It's just, again, it's astonishing that the memo hasn't reached this place, that full-time, full-duty policies, blanket policies that say no accommodations for this kind of person with a disability is just, you can't defend it legally. You just can't.
And the fact that they could make the arguments like they didn't know where the policy came from, and they could say that with a straight face that it might come from Pashi, while other Pashi universities were making exactly the opposite choices. Westchester, for example, was like, nope, we are not going back because we look at science, and science says it's dangerous out there. We looked at, other Pashi institutions that I assume got the same memo, right? It's astonishing that they could say that they just, we don't know where it came from, as if it dropped out of the sky.
Well, and, it doesn't matter where it came from. You're the ones that are implementing it.
That's the point.
And, one of your defendants is the chief equity officer, essentially, for the university. He has an obligation to understand that you can't have a blanket policy. And they kept saying, oh, it's not really a blanket policy, but we look at individualized circumstances, but all of these requests are going to be denied. And that's what a blanket policy is.
Right, exactly. You're just giving me the definition of what the word means.
Right, exactly. So,
it was used for everybody. There was no interactive discussion. There was no consideration.
No, there wasn't.
And, for your audience to know, because I do think it's important to realize this, there is still another lawsuit pending against Kutztown University on this very same issue.
That's not your case. That's an additional case.
No. A completely different case, but still against Kutztown University for their use of these exact same arguments. And as I've mentioned, I've been talking to people in the Pashi system from other schools, and frankly, I've been informally helping faculties across the country who have heard about this story and who have heard very similar denials of accommodations. It does not seem to be all schools, but there are, for varying reasons that I'm not fully clear on. Mm-hmm. Some schools have decided that this is the hill they're willing to die on.
Well, that was originally, when Hawkinson gave out, right before 2021, he put out this really angry video. It was supposed to be like a welcome back video, but instead he was sitting there and he looked angry through the entire thing. And he basically said, you got to have grit and fortitude, just like the working class students that finally came back there. And I did, again, I was so angry. Sometimes the best way that I deal with when I'm so angry at something like that I'll just kind of use humor. And so I posted this video of him kind of in the background, and I used the, that King from Shrek's voice when it comes on. Some of you may die, but it's a sacrifice I'm willing to make, right? Because that's essentially what he was saying, right? It's like, you got to be kidding me. But I digress. So this, more cases are pending. We see that Kutztown was an outlier in some ways, right? Although it goes on at other Pashi institutions too as well. So it's clearly not ended. The lesson has not been learned. So, but for your case here, you win this case in last summer. But that's not the end of it. Like, right? I mean, why is this case still going on if you won that case?
Okay. So we won on summary judgment, which is a process that happens after you finish discovery. As I said, usually the defendants file for summary judgment. And they did here, but we were the ones that were driving summary judgment. And like I said, it's very unusual for plaintiffs to file their own motion. So it's an interim order, sort of, before trial. And so there wouldn't be a trial on those issues because we already won them. So that was the whole point of doing it. So
let me just get this straight. So the university basically says, okay, we give up and ask for a summary judgment?
Well, they asked for summary judgment too. Like, oh, dear judge, you should rule in our favor. Well,
gotcha.
The judge could rule in their favor because we have all the undisputed facts on our side.
Right.
So they lost. They won a couple of the smaller claims, and there was a whole issue about access to damages remedies because of certain cases that have been decided in after we started the lawsuit. But anyway, that's neither here nor there. But so we brought accommodation claims, which don't require any finding of intent. Here he is. This is reasonable accommodation. He can do the job with it. It's basically a strict liability claim. We won on that. We won on the intentional discrimination claim. We won on the blanket policy claim. We won on the interference claim. Which is basically the university was employing policies that interfered with the implementation of the law. The judge said, yeah, that's exactly right. So the bizarre thing was he decided, that the intentional discrimination is a blanket policy that, applies to these particular people. So the other claim we brought was called a disparate impact claim, which is, it's a different kind of claim, and it's important for lots of reasons having to do with access generally, and so basically what it says is you're using a policy that not only intentionally discriminates, and we think we can win that, but when you bring a lawsuit, you don't necessarily know. So you bring the other kind of claim, the disparate impact claim, which is, this policy has the effect of discriminating against this particular group of people. So he already found out that they had a policy like that intentionally discriminated against them. Then he said, well, yeah, I did find that, but you have to have statistical evidence. You can't have a disparate impact claim with one person. Well, the whole point of the disparate impact is that he gets treated like all these other people in this group.
Right.
But in a disability context, as opposed to, let's say, race discrimination or gender discrimination, we don't have to have statistical evidence because the statute specifically talks about an individual, because the whole point was that people with disabilities are being treated differently on an individual, this person, that person, some places might only have one person with a disability. So if you have a policy that automatically excludes them, the law was intended to prevent that. So we filed what's called a motion for reconsideration on that issue, and the judge reversed himself, which he really had to because, the statute itself showed that it was wrong. And so he did that. So
he reversed himself and found in your favor then at that point.
Yeah.
And he found
so
in our
you
favor,
don't have to have statistical evidence for a disparate impact claim in a disability context, which is the right
Interesting.
ruling. So, and really, it didn't change like the remedial effect of the case, but we just felt that it was really important to get the law right because, this case is going to be applied in other places. And, there might not be such good evidence in some of those places on intent, which we had. So we had both, so anyway, so that took some extra time. So that's kind of where we're at. So basically in all of the discrimination claims, we've prevailed. So
this was now, so my question is that, so now there was just another ruling in January, correct?
Right,
Was this the one you're just talking about there?
Yes.
Gotcha. So that's when he reversed that kind of, that's what came down in January.
That's correct. On that one disparate impact charge.
Okay, great. So now we're done, right? You won the case. It's all over.
the whole idea of summary judgment is you only are entitled to it if there are no questions of fact. So there is one retaliation claim left against the university, and basically the judge is like, that's a question of fact. So that is scheduled for trial in May. So I don't know. There are a lot of things that may happen between now and then, but that's what's on the schedule. So we've finished everything except that, and then
So, and I think Lori alluded to this earlier. So the trial is on this remaining retaliation charge that wasn't fully resolved in the summary judgment. But going in there, Kutztown is already guilty on all these other counts. So there is a jury that will be there, and they will be told that Kutztown was found guilty on all these other counts, and they're only here to resolve this one retaliation.
And that is like whether or not they retaliated against you.
Whether or not they specifically retaliated against me. Yes.
And so just so that we're kind of understandful, what does that mean? And like, what does that mean exactly? So if they find going there, what are we trying to figure out? Are we trying to figure out if they're just kind of saying, yes, indeed, they retaliated it, and the jury is now going to decide upon that? Are there other consequences the university will face as a result if you win that as well?
Well, I mean, there is a damage claim attached to it, so
Yes.
There are a lot of things that can happen, but yeah, I mean, so I mean, who doesn't want to try a case you've already won?
That's a good point.
I don't know, a litigator's dream, So anyway, although it's also a nightmare for other reasons. I mean, we've already come this far. We've got, all of this stuff already resolved. So we'll see what happens. But that's the next thing in terms of litigation calendar. And, I always tell people, especially smart people like these clients, that I believe that people who bring a lawsuit, especially an employment case, that they should be required to read Bleak House, like Charles Dickens. Because,
Interesting.
Yeah, because, that case is all about the legal system and how it kind of chews people up and spits them out. And people, their lives revolve around this lawsuit because it's so important and it's so life-sucking. It takes so much time. And then you have all sorts of delays. And at the end of the day, you could end up with nothing. But, the wheels of justice grind very slowly, and this has been no exception. I mean, the federal courts have a lot to do. And, because of COVID, they were really behind.
Yeah.
Because federal judges have to decide criminal cases. And the jury system was totally shut down for a long time. So motions weren't getting resolved in civil cases because, all the criminal stuff had to go. It always has to go first, but it really had to go first now because there hadn't been any trials in, a long time. You couldn't bring a jury into a courtroom, during the early part of COVID. So the system was slower than it probably ordinarily would have been because we were dealing with stuff like that. So, that's part of why we're still here, because it's just been hard to get things to move as fast as maybe they should have or we wanted them to. Because really, like once we got the TRO in Steve's case, we did the discovery, we got it over with, we filed our motion, and then we waited. So,
Well, so let me first zoom out, and then I want to zoom back in again because I'm want to kind of bring this back to you, Steve, in a minute. But I mean, for either one of you to kind of, I'm thinking. So we've been focused a lot on Steve's case, obviously, right? And what was happening here and what the university did. But if we zoom out just a little bit, I mean, we could talk in more broader terms about the implications that this case may have when we're thinking about ADA or kind of, discrimination against folks with disabilities more broadly. I mean, I think about, my sister is, she's got a mental disability, right? I mean, she's as a result of medical malpractice, and when she got kind of encephalitis after having the measles, mumps, rubella shot when we were young, we happen to be one of these families that has a 1 in a million. We are the one in the million that has a bad reaction to this stuff, and then she was administered bad stuff. She got brain damage as a result of that, and it goes on. And so, my experience seeing things, the treatment of folks with disability has been pretty firsthand, and it can be, pretty brutal. cases like this seem to me that they have implications that go far beyond what the Poshki system does, or and like Steve's personal kind of quality of life, although that's absolutely critical. Does this have broader implications for how we think about the ADA and how that people with disabilities will be or will not be protected going forward?
Yes, I think it does. And, because as I said, this whole issue of remote accommodations has been hotly contested before COVID for years. The EOC has issued regulations or guidance in 2002, said you can't just say no. You have to look at each case individually. You have to look at the job, look at the specific things the person can't do. Can they do that job remotely? Now, there are lots of jobs that you can't do remotely, I mean, that's just a fact of life.
Right.
But there are a lot of jobs that you can do remotely. And, the issue that came up in a lot of the early cases as well, you have to be, one of the essential functions of a job is showing up, and that might be for some kinds of things, but, it's not necessarily true for everybody, especially in this highly technological age that we work in. And this is a specific kind of job where clearly the options are so enormous for, accommodating people with disabilities and bringing them into the fold, So I've always said this isn't just about COVID. Mm-hmm. It's about that. It's about sort of bringing to fruition the things that the courts have said. Like, back in, I think it was I can't remember what it was, 1980 or 79, something, the Supreme Court decided a case called Davis versus Southeastern Community College. And it was a case involving a student who was deaf, and she was a nursing student. And she couldn't hear things that were going on in the OR or wherever it was they were doing the training. And so she wanted to have a separate kind of clinical program for her, so she wouldn't have to do that. And the court said, well, no, I mean, again, this is not an employee, so we're doing fundamental alteration.
Right.
That will fundamentally alter the nature of the educational program. But the court said the time might come when such accommodations, based on the advances in technology that we all know are coming, so such accommodations might be reasonable. And there are a number of other cases that said similar things, like, well, this guy loses or this person loses, but someday, maybe they won't lose. Maybe we'll have better stuff, Well, we have better stuff now. Mm-hmm. So that's why I think this case is it is important. People are watching us,
Yeah.
And can I add, if you have enough time?
No, please.
There's another dimension that Lorrie and I have talked about, and I think is important to mention here. The ruling in my case was, of course, that there were no penalties and there are no emotional distress damages available. That really comes out of a April 2022 ruling by the Supreme Court, Cummings versus Premier Rehab Keller, I guess is the full name, where they decided that disability claims could not receive any emotional distress damages. There's controversy about that decision.
I would say.
They apparently, by some accounts, they took contract law too literally and ignored the fact that in some past practice, contract law did allow for emotional distress damages, but there were gaps in the way the law was written. And the Supreme Court noted those gaps, but they issued this ruling, no damages. Well, one of the consequences of that is it's going to make it much more difficult for people with disabilities to find representation in the case of institutions or businesses discriminating against them. And so one of the other implications besides, as Lorrie was talking about, the access that I think is important to take out of this is that the Cummings decision has to be challenged. And for us, we're taking a step towards this. And there are other groups doing this as well. But we have a meeting set up in in March. The trial's in May. But we have a meeting set up in March with some aides from John Fetterman's office, where we're going to talk about this problem. And I'm considering reaching out to Madeline Dean, the Congresswoman Dean, and perhaps Senator Casey as well. Dean represents my home area as well as Kutztown University.
Yep.
So I think it's going to be important to reach out to the legislators and fix these gaps that the Supreme Court rulings are capitalizing on to remove damages, remove that possibility. And not just because people might get damages. The reality is that there are certain types of discrimination where there are no other financial issues. I mean, mine happens to have salary and benefits.
Right.
There are other cases where discrimination is really just you're prevented from doing something or having access to something. There's no financial loss. And it was always the case that the emotional distress charge, plus potentially punitive, were to punish people who are violating the law.
Right.
Yeah.
And that's now gutted with the Cummings decision.
I want to just point out that our case was brought under the Rehabilitation Act, not under the ADA.
Yeah.
Cummings applies to Title VI statutes. So it would be the Title VI statute was like the grandfather statute for public fund recipients. And then we ended up with Title IX, which applied, for gender, we have, the Section 504. They're all sort of related. Now, the difference between Section 504 and some of those other statutes is that all of the statutes, they applied no matter who the federal fund recipient was. Mm-hmm. So it could be a hospital, it could be, a public school district, it could be a university, it could be anybody that, receives federal financial assistance. But, when Section 504 was passed, it was so clear that one of the, the basic principles was that it had to do with employment. So clear that Congress had to the next year, amend the statute to make it clear that it applied to other things too, not just employment. Yeah, it applies to transportation, it applies to all these other things. So Cummings was not an employment case. It was a public accommodations case. And so the court in Cummings, issued this broad brush decision that affected employment claims. It didn't actually say that. It didn't use the word employment, didn't use the word job. It's unclear whether they even knew that their language would be interpreted that way. And we made, I think, a really sophisticated and compelling argument that it actually didn't reach employment claims. Now, the judge, I understand we put him sort of out on a limb a little bit, but if the case were ever to be appealed, that issue would be going up. Mm-hmm. So, I think that we just have a really strong argument that isn't actually what it was supposed to do. But the problem is, and the reason that we brought our case under Section 504 is because the ADA originally, was supposed to protect state employees, mm-hmm. but the Supreme Court gutted that too with regard to state employees. So you can't get damages against them. All you can get is injunctive relief and attorney's fees, basically. You might be able to get back pay. I'm not positive about that. But anyway, so when we brought the case under Section 504, it was before Cummings was decided. So that was a real sort of, blow, it kind of changed the whole landscape. But it is hard to get people to take these cases. People like me are always going to take them if it's a good case. Because, one of the things you get if you win a civil rights case is you get attorney's fees from the employer or whoever the defendant is. But let's face it, we have a lot of cases that aren't as good as this one. And these cases are expensive. They're time consuming. Here we are 2.5 years later. I'm still spending a lot of my time on Kutztown cases. I can't do a whole lot of other stuff. And, so it's very difficult to get people. And then the Supreme Court, like in 1990 something, I can't remember exactly when, but they said, you only get attorney's fees if you actually win. You don't get them if you settle, unless you have enough power in the relationship, which we do, I think, in that situation. So they'll pay you anyway. But So it's been really frustrating during my career to watch, Congress pass these laws and then the Supreme Court step in and says, oh no, you can't have that. And it's fallen really heavily on disability, so it's very, and the reason that we have like attorney's fees provision in civil rights statutes is because these laws aren't self-executing. Someone has to bring the case, so they call them the private attorney generals, they bring these cases and enforce the law. We can't enforce the law if you don't have any consequences.
Well, and that's what I worry about with the, I mean, to be honest with you, is that's the part about the damages that is most concerning to me about what's gone on here, in part because is like, what really are the repercussions that have been faced by Kutztown, President Hawkinson, Jesus Pena, or all these people that put in these policies? If they cannot be, if they're protected because they're state employees, so therefore they can't be sued directly, right, under these provisions. If they're the university and the individuals are not going to face kind of financial cost to this, they can just dismiss this as a cost of doing business and have their personal kind of belligerence kind of being, thrown out for the world to see. I mean, and I hate to say that because you would like to think, I mean, there was a time when I thought that, okay, in the end, people are going to do the right thing. Well, this is a perfect case where they don't. And it seems like if they're not going to understand reason, they're not going to talk about the force of law, then the only thing really left is a personal, like, a repercussion or consequence, like losing your job, like president of the university, right? Or, right, financial loss, where they're going to face consequences and have to kind of deal with that. And unless we have that, I mean, okay, great, we got the law settled, right? And Steve, thank God you've got your job, right? And thank God you didn't kind of end up being kind of forced in a situation where you were going to kind of like put your life at risk. So that's good. But as we've seen just in chat tonight, as you've said, you've talked to other folks in the Pashy institution and at Kutztown, they could just dismiss this as cost of doing business unless there's some kind of serious consequence.
Well, I mean, don't get me wrong. If you lose a civil rights case, there's going to be a serious consequence because you have to pay the lawyers, and that's not insignificant. On the other hand, it's also not a remedy for the plaintiff. Like, I'm not in this, for any reason other than, to get relief for the plaintiff. And I'm a law reform person, so that's important to me. But
yeah.
But we made really compelling arguments on both of those fronts, on Cummings and on the, because the judge did dismiss all of our damage claims, and except for the retaliation one, which is that's what's pending for Cummings. So that's all to be decided later on. But that's kind of where we are, because I mean, I agree. I mean, I just think it's really short-sighted and just totally, it just shoots the law in the foot.
Yeah.
And the reason, like, Congress, amended all of these laws in 1990, because they realized that you had to have damages in order to be able to enforce these provisions. But under Section 504, the damages were already there because, it's a totally separate type of statute. But so those issues are going to get litigated. They're going to get resolved, if not in this case, in another case. But those, and we're not the only ones on the planet who are working on these issues either.
Right.
Yeah.
But so it's frustrating. It's really frustrating, especially when the law changes like that in the middle of a case.
Yeah.
Oh my God.
Well,
I know.
I gotta admit, I'm quite angry about this because I would like to think, like you mentioned, Kevin, that after it was pointed out that the policies violated the law, and after having a ruling that highlights this, you would like to think that our so-called leaders say, let's correct this. Let's make this right. Let's change what we do. And we haven't heard a single word from Hawkinson and Pena about how they're going to revise their actions towards ADA accommodations. Not a single word about it. And
well, I did see at the end of every email that they write, it does say, we don't discriminate.
Yeah, that's what they say. But
anyway,
they
sorry.
They didn't even follow that policy. Yeah. But I don't hear from our council of trustees either. right? And they're supposed to be overseeing, to some extent, the policies and actions of the president, at least advising in some cases and overseeing, I guess, in others. We have lawyers on the Council of Trustees. You would think among this group, somebody would be pointing out, we have to change our behaviors. Okay, they're not going to get damages, fine, but still, change the policies, change the actions of the university, show some remorse for mistakes made and corrective actions. I don't see any of that at this point. So I get quite angry about this.
Yeah, well, sorry.
And it's beyond my case. When this whole thing started, I said, yes, I'm personally involved, but it's not just about me. And that's exactly where I'm sitting now. Okay, we'll get some resolution, but no damages. Okay, but then let's make sure this doesn't happen for others. How are we doing that? I don't see it yet.
Yeah, and it would seem, I don't know. I mean, as a university who is as concerned about its public relations as possible, I mean, one of the things you have in PR that, you learn, I mean, I'm friends, my department who teach in PR, right? Things like this will tell you is that, if you do wrong, right, the best thing that you can do is apologize and move forward and say, we're going to make it right. Right. I mean, and very publicly, right? Because you want people to know that you're not the kind of institution that's hypocritical about saying, hey, we're a caring community, but you've got a disability, we're going to push you in the rug. If you, happen to be kind of like facing racial discrimination or kind of sexual harassment, we're not going to talk about that because we're going to do the image. You want to be kind of out in front about it, would seem to me. But I guess, yeah, you would think. And so, Steve, I guess as a way of kind of moving this, I mean, I think it's fair to say that your life has been significantly changed by this, right? I mean, you're involved in advocacy organizations nationwide and all this stuff now. I'm curious kind of a little bit kind of more locally. I mean, because I could imagine it, coming back to work, right, has got to feel kind of, I don't know, mixed at least, right? I'm coming back in the sense that at the university, but at the same time, you're there doing a job that you love, right? That, and I've said this when you were on the show before, I've said this 1,000 times to anybody who will listen to me, is like, you, for me, always stood as one of the kind of models of the person who was willing to do the work at the university, right? Even when others don't. And I take people back all the time for when you kind of volunteered. Okay, I know something about assessment, so I'm going to take that up. I remember sitting with you in a room, like, and me being the belligerent guy in composition, being like, nope, not going to do it. Nope.
You were in one ear, somebody else was in the other ear.
Yeah, no, exactly. But I mean, you didn't do that because, that you just you were doing it so that, whatever, you could rise up the totem pole, so to speak, No, you were doing it because, okay, you wanted to give. You say, this has to be done. I've got the skill set that's going to do it, so I'm going to step up and do it. And, so for me, I grew up in Irish Catholic working class family that's knows how to hold a grudge to the grave, right?
Yep.
I mean, what's the experience been like coming back, right? I mean, and what's been the response that you've got from, say, colleagues or the community, kind of a response to your case? I mean, has there been that kind of show of support? Has there been kind of people stepping up and saying, we're with you, Steve?
Well, look, I'll step back to say that when I was going through the rehab, I was excited to have the chance to come back to work feeling healthier because I had struggled with the health for so long. The fight with the university has completely drained me of that enthusiasm.
Yeah.
Now, did I get support? Yes, from a lot of individuals, obviously yourself and others. Not very strongly from the union at first. It has gotten better, but bluntly, I don't think they've gone far enough in supporting the fight. I've heard that the lawsuit was a topic of conversation during negotiations of our contract. But whenever I ask Ken Mash, well, what exactly is the outcome of these conversations? What is this lawsuit going to do in terms of our contract? I don't get an answer. So I sit there and say, is this having any impact? Has the union pushed hard enough? Have they, been militant enough as I think they needed to be? No, I think the individual support from a lot of people has been there. A lot of people have spoke up and contributed to this. I think the union, as I said, has gotten better, but I don't think it's gone far enough.
Yeah.
And I sometimes tell myself and think about it in this way, that disabilities, yes, that's the class that I am in, but it's a basic discrimination issue.
Right.
It is an issue of, well, how is the university going to respond to other populations that are
exactly
differences in sex, differences in race? We currently see an issue on our campus and in the PASHE system being raised about the treatment of people of color.
I got this right here. This is Senator Art Haywood's kind of report that came out, but just about kind of racial discrimination across PASHE campuses. And now there's going to be this listening tour. An announcement just came out. We want to hear this and kind of getting on board. Seems to me is that this is another facet in the kind of case that you brought forward. Because look, there has been a long history of racial discrimination on our campus that I've heard it from students. We know this has had faculty. There's been faculty that have been driven out of the university. These things, there. So this case, in my mind is like, I'm thinking, okay, yes, your class here, disability, but we've seen ongoing harassment. I know faculty members, women faculty members who have been harassed by administrators and things like this, and it's brushed under the rug. Other administrators were decided to encourage to leave the university rather than have exposed what had gone on, and then given a glowing recommendation so they can go on and kind of commit the same kind of things at other PASHE institutions, even for that matter.
Yes.
So this is, these are the kind of things where it seems to me that everybody's got to be, here. I mean, I would agree with you. I mean, when I look at that, kind of from the union perspective, I mean, very well, I was involved with our union for quite some time. Matter of fact, what happened around the COVID accommodations was really something that kind of broke my heart in many ways, because there were groups of people who were attempting to put together a reasonable sets of accommodation coming forward from the union, and then were kind of dismissed out of hand. That we're basically told, no, we're not going to do this. We don't want to kind of rock the boats. And our local, union leadership was not there to fight the fight for faculty members. So, I mean, I think that this can be, it's another moment of reckoning in my mind. And I don't mean to go on here and diatribe about this, but it seems to me that it's a really important moment in this case. I want to highlight it in every possible way for exactly the reasons that you just said.
I will say I have a grievance against my dean right now for something I believe, I'll be careful how I say this, but I believe is driven by retaliation. Mm-hmm. And the union is supporting me through that.
Yep, it's better.
And I've also been in touch now and have been, I guess, officially made a member of a subcommittee for the social justice at the state level. So I think I'm going to be able to have a larger voice in some of these issues. Whether it's enough to generate some momentum, I'm going to use the metaphor coming up, I guess. The jury's still out, in my mind.
Well, I mean, I think that something that is really important about the case is the union can use this to help advocate.
100%.
I mean, the union, your union contract has an accommodation provision in it, So, I mean, they don't, like the union is a totally separate issue. Like we're not treading on their turf and their, we live in different planets in a way, but, I always feel like fundamentally we've got the same interests at heart. But, I'm just really hoping that what we've been able to do on the litigation side will help them, because the last thing that most people need is a lawsuit. Like I said, this litigation is not for the faint of heart at all. I mean, it's just really difficult to do this. And, so it would be great if this kind of result could, sort of be used as okay, this has been this case. We have this case now. I mean, and we have our own accommodation provision. So let's try to, be proactive so that we can keep most people out of court. Because that's really the goal. So for me, I'm really hoping that there's a translation between what we are doing and what people can basically do for themselves, or that the union can help them do.
Well, I hope so too.
Implementing its own contract, yeah.
But we're going to have to see how this lawsuit had any specific impact on this new contract. We don't have enough details about it right now, but that's my hope, is that it had something concrete to enhance our ability to protect other individuals in the future.
And we're hoping that it will also, help other people. Because one of the things that I was so amazed about when we first started this case was that there weren't any more, like around the country. There was one that sort of started before we got started, and I'm not even sure what happened to that. But there's another one I know of in Georgia, and there are a few now sprinkled around, but there aren't a whole lot of them. I think part of it is because it's so difficult, and people, were really concerned about like a lot of that case law that had been developed before COVID, like, oh, the law is so bad on remote accommodations, and well, they say it's an essential function for you to be at work, like in the classroom, the physical classroom. I mean, I think a lot of people out there, are not. I don't want to. I don't know. I guess I should think about this differently in terms of how I say it. But
I know what you're saying.
You have to be willing to sort of put your money where your mouth is, right? Exactly. That's how I feel, and it's just hard. Not everybody can do that or wants to do it, and it's a big risk, because you are devoting a huge amount of your life to a case like this, and you may or may not get paid at the end of the day.
Yeah.
Well, and I just hope that this is like the opportunity. We had a recent case there's ongoing cases here in my own school district, right? Discrimination case, ongoing racial discrimination cases. The Education Law Center has been working with us on this and all this, but it's like, I always think about these are really kind of the opportunities for spine building, right? Because I think sometimes people are afraid to fight. Put the difficulty stuff. I hear you 100%. We can put that in this one box. That's not going away. But there's also the will, right? The belief that you can win. And, that's also the lessons that we talk about a lot in this program about, this is the history of social movements. You can't win if you don't fight. That's just a square one. You're not going to win every single time, right? But you can't win if you don't fight, especially when you got a case like this, which was a slam dunk, right? It should have been like you said, you should have bring this forward, and they should have ran away with the tails between their legs and saying, I can't believe we didn't, that we even tried to do this. It was so morally reprehensible. I can't show my face in public anymore. But no. So,
well, I guess I might quibble a little bit with the slam dunk, because in spite of everything that we said about how great we think our case is and how much we believe in it, because Steve and I are both on the same page about that, and we have been on the same page from the outset. And we were both really committed to it, and believe in our ability to see it through. But litigation is never a slam dunk.
Fair point.
It's really hard work, and anything can happen. And at the end of the day, it doesn't matter if we do everything right, and we don't get to decide. So, that's sort of where the whole risk analysis comes in for, people who, may just have a different perspective or have other things to do, or, just don't really understand like how the law really has been transitioning for the, last 30 or 40 years to where we are right now. And I see things like some of the listservs I'm on, for employment lawyers. Oh, well, you can't get a remote accommodation because of this case that was decided 20 years ago. I'm like, well, that case actually has really good language about now, but I think a lot of people, if they don't really specialize in this area and like spend all their time on it, they might not know that,
Well, let me. I've taken so much of your time tonight, and I appreciate you really of talking this through, because this is, for me, this is just has been such an important case that obviously I feel viscerally in many ways. It literally, like I said, just kind of broke my heart to see what happened, especially after a year before this happened to Steve. This before COVID, we had an adjunct faculty member in a different department who was told they had to have like emergency surgery in order to or they were going to die. And the university fought any kind of accommodation. We had faculty members stepping up, and our union president at the time, Amanda Morris, basically said, look, we can use the faculty sick bank to make sure that this person has health insurance so that they can stay work. And the university said, nope, we won't take it. And they fought that. And then that was disgusting and despicable at that point. And to see them, okay, I guess we learned our lesson from that one. Let's do it to Steve now. Let's do it to these other faculty members. It's just pretty incredible. But the point, as both of you have said tonight, this is not just about you, Steve, right? That this is going to have impacts far beyond what this case goes. And we've got people in our chat tonight already saying, yep, this is happening to me here. So if we had to kind of close this out as a way of thinking about, okay, if you're a person who's listening to this out there, whether they're in the PASHI system or in their other workplaces that are facing these kind of cases, do you have some kind of suggestions of kind of where they can go, where they could go for contact, or anything about the other work that you're doing? I know, Steve, you're doing some great work with younger folks around the country too as well. What would you want to leave folks with here about kind of where to go and what to do and messages for where we go from here?
Do you want to start, Lori, or?
Well, I actually hope they'll go to the union, because I think we have something for the union to work with now. I mean, they're not starting from scratch. They're not having to pave the way. So, like I said, I think that would be a really good place to start. Now, the realities are that I understand how that process works, and
sure,
the university gets to say what they're going to say. But you would just
when you look around, I'm sorry.
That's okay.
I was going to say, what you have to take into account the fact that not every university, since that's our primary setting here, not every university has a union. Right. So you would hope unions step up first.
I actually think about Kutztown or,
But some of the people I'm talking to from other universities don't have that.
I know.
I reached out, for example, to the EEOC, but there was such a long delay from when you first contacted them to when I finally got an interview to see whether they would take the case, that it was past the deadline. Kutztown was threatening to fire me, so I couldn't follow that path. I approached as I mentioned earlier, a nonprofit, I guess nonprofit, but the disability rights organizations in states. And the one from Pennsylvania was quite helpful. They obviously didn't manage to resolve the case, but they were quite helpful, wrote a strong letter on my behalf. I'm finding, working with other faculty in other states, that the analogous organization in different states is not always as strong as Pennsylvania seemed to be. But it's a way to start potentially without having lawyer fees. But the reality is, I think, with these kinds of cases, you may ultimately come to a lawyer. And fortunately for me, when I was looking, Lori had expertise, obviously, in employment, but also disability issues. So I found that to be a particularly compelling background for mine. So if I'm going to recommend somebody, I'd say you have to find lawyers that have those as specialties. And lawyers can speak to whether somebody like in this firm like she has versus larger firms, what might be more helpful. There's a series of steps that you have to look at. And
well, on that score, do you regret going forward with this case?
Oh, heck no.
Yeah.
I mean, heck no. Laura's like, please. No. I mean, absolutely not. I praised Lori to everybody who will listen. But broader than that, when I came out, one of the things the doctor said is that during this recovery phase, first year or more, I had to do everything I could to minimize stress. And within 6 months, I'm fighting my employer. Do I regret that? Hell no.
Yeah.
What they did was wrong. And as you said, somebody had to stand up to them. And I was fortunate to be in a position where I could, tenured and closer to retirement age. I wasn't worried about promotions, tenures. But that shouldn't really stop anybody. But still, it was a privilege I had. And then I also have the attitude, I guess, that I was willing to fight this. And you mentioned spine. There's a certain amount of, you have to recognize you may not win, as Lorrie mentioned, but you have to recognize you have to go into the fight when somebody's doing something wrong.
Well, and let me be clear, the reason I asked the question too about, do you regret it, is because I know that when you're at the beginning of the process, sometimes it's hard to see this moment, right? To see this moment of saying, if I stand up and I do what's right and I fight and I know that I'm right on this one with all the risks that are involved, right? That feeling is important, like looking back on it.
Yeah, but you have to take that first step, and I was willing to do that. Yeah. And I felt, like I said earlier, I felt really confident about the case, knowing that it wasn't going to be my decision and things could go wrong. But if you honestly believe that what is being done is wrong, you have to do something. We have way too many cases where people are not stepping forward. And if we want to make it better, not just for ourselves, but for people who are going to follow us, somebody has to step up. And frankly, it has to be more than one person. Yeah. So, I'm proud to say that there are multiple people from our university who have sued. And I'm hopeful for their outcomes, because one is still pending. But we need that. I'm glad to see that another lawsuit was filed at another Apache school. I'm hopeful that people from the other schools, if you're still listening, take the step, because I've talked to quite a number of this. It's going to take some time. Yeah. But you got to do it. And I don't regret it. Have I gotten disappointed and frustrated and angry along the way? Sure. The emotions have gone up and down, but it's never gotten to a point where I've regretted what I've done. Yeah. In fact, you may know, I've publicly shown up to talk to the president about this. Yep. And I don't get him to talk about it, but I'm going to be there to highlight what's going on. Yeah. And so, we'll see what some of the planned actions coming up will do. Got to step up. Hopefully people will.
Well, fantastic. Well, listen, go ahead, Lorrie. I'm sorry. Go ahead.
They don't have to invent the wheel. I mean, we've invented it.
Yeah. This is a big deal now that there's a track laid down.
Right. Exactly. So it's always hard to be first,
Yeah, and that's exactly it. You gotta start that path, and then after that path gets started, more people walk that path, then it becomes something bigger. Which is also one of the reasons that in the show notes that you're going to find a link to Lorrie's legal firm, so that we'll put in more information about all this. Social Studies Rock says basically, thank you so much for starting the process. Yeah. That's pretty awesome. And I want to thank both of you so much for spending as much time as you did here with me tonight. I know it was a big ask, especially for this amount of time. For you to, you've been so generous with your time and helping explain this, but even more so for willing to take on this fight. And I think that I know, Steve, that couldn't have done it without you, Lorrie. And Lorrie, I'm glad that you're the person that Steve ended up with, because this is one hell of a kind of dynamic duo, I have to say.
Yeah, she might regret it, but I'm.
I always tell Steve, I know you're frustrated, but I'm actually having a really good time.
It's like, I'm in my lane right now. I know.
Yeah.
Wonderful. Wonderful. Well, listen, we're gonna, I'm gonna keep on following this case, and Steve, always if things come up, right? Developments in the case or whatever like this, that it's not right on my radar. Let me know. I'd love to have you back on to talk about any aspect of this. It'd be kind of cool to hear. I know that you're starting some webcasts or web series that's gonna be with some young folks. I'd love to even down the road, once that kind of gets rolling, to talk a little bit more about that. That'd be really cool.
I'm going to be setting up a place to discuss this further and have resources. So some type of blog site where there'll be documentation of my case, discussions, other information that can be easily accessible to people. I haven't got there yet. I've got something else I'm trying to finish first. A couple things to finish first, frankly, but I will be doing that.
Wonderful, wonderful. Well, listen, thank you both so much for coming on the show tonight. I'm getting lots of kind of little messages here, kind of comments in here about excellent discussion, and thank to all of you for the work that you continue to do. I know this is going to have an impact far beyond your case, Steve, and I know that Lorrie, that being an expert in this and being willing to take on this fight and kind of like never look back and have fun with it is even better to hear. Is kind of what we want, right? This is the kind of fight that we love to highlight and showcase here. So thank you for being on the show tonight, and look forward to the kind of next round, I guess, coming up.
And Kevin, thank you for the opportunity. I mean,
Definitely.
you've been a supporter from the very beginning and given me a forum to talk about this early and continually now. This is big. This is big for me that you were willing to do that.
Oh God, are you kidding me? Anytime. I mean, this is it's a small contribution that I can make to this fight, kind of in this whole thing. So I just appreciate everything that y'all are doing. So it's great. Well, I got my daughter coming down the stairs saying, "Hey, look, it's getting bedtime coming up." So I'm going to go see how she's doing. Let you all off the hook for the evening. Thanks so much for your generous time and for the fight that you're waging. And we will hope to talk to you soon. All right, everybody. Thank you for tuning in for this show tonight. This has been one that I have been super looking forward to. As I said, I appreciate the comments and the support. Make sure you share this out everywhere you can. We'll talk to you soon. See ya!
I guess I'll fly